Hi everyone, welcome back to The Art of the Matter. I'm Harun here. I have disappeared for quite some time. Today is the first episode of this new era, the era of New Malaysia. So welcome back. I'm glad to be back. We are going to talk about a very important case that has been decided by the High Court, by the Court of Appeal, and it went up to the Federal Court last year. The case that is going to have a lot of relevance during this new Malaysia time. It concerns the question whether the Prime Minister is a public officer or not, and whether he therefore could be sued for misfeasance while holding a public office. Now, let's recap what happened. In the case that was filed by Tun Dr. Mahathir when he was still the opposition, he sued Najib Razak, the then Prime Minister, for misfeasance, claiming that he has abused his power and claiming damages. I feel, and many Malaysians feel, that there is something wrong with the decision of the court. Basically, what the High Court held was that the tort of misfeasance, in order to be successful, the plaintiff, i.e. Dr. Mahathir, must show that the defendant, Najib Razak, was a public officer. And in this respect, the High Court looked at the Interpretation Act 1967 and referred to the Federal Constitution, and the High Court held that the Prime Minister is not a public officer or is not part of public services, and therefore the action failed. With all due respect to the High Court, the Court of Appeal and the Federal Court, I disagree with that. The reason being this: the tort of misfeasance is not an action brought under any written law of Malaysia. Yeah? It is an action under the common law, unwritten law, which is also applicable in Malaysia. The tort of misfeasance is established through a case known as the Three Rivers case, Three Rivers District Council against the Bank of England. Yeah? Basically, Lord Stein in that case says the rationale of the tort is that in a legal system based on the rule of law, executive or administrative power may only be exercised for the public good. And Lord Hobhouse said that the tort concerned the act of those vested with governmental authority and the exercise of executive powers. That's what the tort is all about. It's not about public officers, it's not about public services. It is about the act of those vested with governmental authority and the exercise of executive powers. That's what the tort is all about. And in another case called Jones and Swansea City Council, Lord Justice Slade held that it is not the juridical nature of the relevant power, but the nature of the council's office, which is the important consideration. So the court is not going to look at the juridical nature of the power, whether he is a public office, public service. It is the nature of the office. So whether that office is occupied for public good or public benefit, that is the crux of the tort. Yeah? It is given a very wide meaning. It is not in the narrow sense of whether you are a public officer, whether you are a public service, in public service or whatever. It is given a wide meaning. And in some other cases, even where laymen like me, where we are exercising or appointed by the government to undertake a government task, we also could be sued for misfeasance. That is how wide it is being interpreted now. Interpretation Act is only applicable to written law. It is not applicable to unwritten law. It is not applicable to common law. So why, in a tort that arises from common law, our court applies the Interpretation Act is really baffling. And with all due respect, I think that was very wrong. Misfeasance, as I explained just now, is based on the common law, which is unwritten law. So when that was the case, one cannot apply the Interpretation Act to interpret or construct whatever legal terms in that case. Have to refer to the common law cases. To me, and I say this with the greatest respect to the High Court and Court of Appeal and the Federal Court, the decision is clearly incorrect. And because it has gone up to the Federal Court, we now have the highest court of the land making, with all due respect, the wrong law. It has to be revised. This matter has to be revisited, particularly in view of and taking into consideration the weekly disclosure of scandals, financial scandal, which runs into the billions of ringgit that have been disclosed to the public every week now. Are we just going to sit and say we cannot sue those responsible people, or rather, we cannot sue those people who were responsible for all this scandal just because they are not public officers? That is all for this week. Thank you very much for watching. I see you again next week. Thank you.